In our video about the decision of the High Court of Australia in Ray Gallagher, we mentioned the argument that the UK was a foreign power. This particular point had been decided by the High Court of Australia in the case that we are looking at today. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will analyze the case of Sue and Hill from 1999. Here's what was happening in this case. There was an election in 1998 for the return for 6 senators for the state of Queensland to serve in the Parliament of the Commonwealth. The writ for the election was issued on 31 August 1998. Pursuant to the writ, nominations were made on or before 10 September and the election was held on 3 October 1998. On 26 October 1998, Mrs. Heather Hill acknowledged to have been elected as a senator for Queensland. The thing was that Mrs. Hill was born in the UK in 1960. She moved with her parents to Australia in 1971, married an Australian citizen, had children here, worked and spent her whole life residing in Australia. In January 1998, she applied for and was granted Australian citizenship. But it was not until 18 November 1998, nearly a month after her election was certified, that Mrs. Hill became aware of the steps that could be taken to renounce her British citizenship. In terms of the timing, we have already seen in a case called Sykes and Cleary that dual citizens must renounce their foreign citizenship before nomination. But that is only an issue under section 44(1) if the candidate owes allegiance or obedience to a foreign power. If the UK is not considered a foreign power, then no worries. And so, because of this context, Miss Hill's election was challenged. The High Court, as the court of disputed returns, had to decide whether Miss Hill was disqualified or not. Since Miss Hill was regarded as a British citizen by the statute law of the United Kingdom, the High Court of Australia had to answer whether the United Kingdom answered the description of a foreign power under section 44(1) of the Constitution. As Justice Goldern said, it is not an issue that the requirements of section 44 of the Constitution must be satisfied at the time of nomination, nor is it an issue that at that time Miss Hill had taken no step to renounce her British citizenship. The issue presented for decision is whether she had to. So, is the UK a foreign power or not? If it is, she was in breach of section 44. If it's not, then the election was valid. What did the High Court say? The majority judgment of Chief Justice Gleeson and Justices Gummel and Hayne begin by saying that a proper interpretation of the expression foreign power in section 44(1) of the Constitution invites attention to questions of international and domestic sovereignty. The thing is, if we consider the history of our Australian legal system, and even if we look at the constitutional changes in the UK Constitution, we will see a different story. And this demonstrates how each legal system, even if their roots are the same, they have evolved differently. In fact, in the majority judgment, the justice said that it may be accepted that the United Kingdom may not answer the description of a foreign power in section 44(1) of the Constitution if Australian courts are, as a matter of the fundamental law of this country, immediately bound to recognize and give effect to the exercise of legislative, executive and judicial power by the institutions of the government of the United Kingdom. However, whatever once may have been the situation with respect to the Commonwealth and to the States, since at least the commencement of the Australia Act 1986, this has not been the case. That is, the UK has its own constitutional history and Australia has its own constitutional history as well. There are many aspects of the Constitution of Australia that relate to the UK, that's true. We share a monarch, the preamble indicates that Australia was formed and the Constitution enacted under the authority of the Crown. The Crown, in fact, is a relevant and constant part of the Australian Constitution. Our common law has developed from the British common law, etc. But since the Federation, the UK was a foreign power to Australia. And even if one does not accept that premise, it is undeniable that at least since the Australia Acts, the Commonwealth of Australia is independent. Australia is a sovereign nation. We have a distinctive constitutional and international character from that of the UK. So if that's the case, then the expression foreign power will apply to the UK. As the justices concluded, the point of immediate significance is that the circumstance that the same monarch exercises regal functions under the constitutional arrangements in the United Kingdom and Australia does not deny the proposition that the United Kingdom is a foreign power within the meaning of section 44(1) of the Constitution. Australia and the United Kingdom have their own laws as to nationality, so that their citizens owe different allegiances. The United Kingdom has a distinct legal personality in its exercises of sovereignty, for example, in entering military alliances, participating in armed conflicts, and acceding to treaties, such as the Treaty of Rome, themselves have no legal consequences for this country. Nor does the United Kingdom exercise any function with respect to the governmental structure of the Commonwealth or the states. All in all, Miss Hill could not have been chosen as a parliamentarian. She was a citizen of a foreign power, the UK, and as such, she should have renounced her citizenship before nomination. In that particular scenario then, the ballots had to be counted once again and another senator sat as the senator for Queensland. I hope you enjoyed learning more about this case. If you did, click the like button. Make sure you are subscribed to our channel before you go, and I will certainly see you again. Until then, ciao.